Welcome to a new episode of Penal Law Presents. Today we're going to talk about issues regarding EMTs who can now be certified at the age of 17. Now, as you probably know, that in 2018, the New York Code of Rules and Regulations was amended to allow that a person who's at least 17 years of age prior to the last day of the month in which he or she is scheduled to take the written certification exam may become certified, right? So in other words, 17-year-olds can be EMTs. 16-year-olds can be certified first responders. So today's presentation is not long, it's not complex, but there are a number of laws that do govern what we're going to be talking about. So of course you have Volume 10 of the New York Code and Rules and Regulations, Section 800.6. You have the General Municipal Law from New York State, which is Section 204.B. -B. You have the Arts and Cultural Affairs Law, believe it or not, which in this case, Section 35.07 we're going to talk about. You have the New York State Not-for-Profit Corporation Law, Section 1402, which we're not going to talk about too much, and Penal Law 260.10. Each of these actually have an impact on whether a 17-year-old serving as an EMT will create issues. Now, there's more we're going to discuss. You'll see FERPA we're going to talk about, but you'll see a couple others as well. So first, let's be clear about what we're talking about and what we are not talking about in this lecture. So fire departments and volunteer ambulance services have two types of memberships. Obviously, if you're an employee, you're an employee. But on the volunteer side, there's basically two types of memberships, for lack of a better word. And an active member, somebody who is subject to call for duty, somebody who responds to calls, and somebody who's then entitled to death and disability benefits like VFBL on the fire side, VAWBL on the ambulance side, but that's the death and disability benefits. Those benefits are available to active members. And those are persons who are 18 and older, and in some cases, less than 18. Normally, in our practice, what we have you do, our clients create for their bylaws, is a category of membership called active youth member or active junior member. They're active members, but they're youth or junior members, right? Meaning they're less than 18. Maybe they're 16 or 17. Now, that's what we're talking about today on the volunteer side. What we are not talking about today are youth program participants. A youth program participant is not permitted to respond to any emergency. That's a New York State law which specifically prohibits a person in a youth program from responding to an emergency. That's not what we're talking about. To be clear, we're talking about persons who are actually members of an organization, of an ambulance service, or of a fire department. So let's give you a little bit of background information. First, the Attorney General has given an opinion that a 16-year-old can be a volunteer firefighter, actually a volunteer firefighter. The same opinion would apply to members of EMS organizations. They can serve as responders, for better words, responders to the EMS calls. Now, junior members have to be defined as a subset of active member. As I said in the last slide, we're going to be talking about active members, and an active member is somebody who will be entitled to death and disability benefits. You can't have a member just called a junior member. They have to be called an active junior member. So again, that's who we're talking about. Now, junior members who, again, are permitted to respond to emergencies, they can have limited rights. So you could say, and we're going to talk about their right to vote, their right to be in the station at this certain time, the right to volunteer at a certain time, how many hours they can give. You're allowed to give specific limited rights to these junior members. So what's the minimum age to be a firefighter? Well, a firefighter, as an interior firefighter, doesn't have any minimum age. You can be 17 years of age. You can be 16 and perform some firefighting skills, and I'm going to talk about that now. But there is no law that specifically says a person of a certain age can or can't be a member of a fire department, or can or can't be a member of an ambulance service, or can and can't serve as an interior firefighter. Now we have certainly a law that says what the minimum age is, 17, to be an EMT. So, let's talk about the minimum age and how the New York State Penal Law actually gives us some guidance on who should and shouldn't be a EMT. And coincidentally, we'll talk about a little bit about firefighting, although that's not the topic of the day. So the Penal Law, which is the criminal laws of New York State, has a law called the endangerment of the welfare of a child. A person is guilty of endangering the welfare of the child when they knowingly act in a manner that's likely to be injurious to the physical, mental, or moral welfare of a child, and a child is a person who is less than 17 years of age. So let's look at that. There is a criminal law, it's in the penal law, that says if a person allows somebody who is less than 17 years of age to participate in an activity that could cause physical, mental, or moral harm to them, then this person could be guilty of violating Penal Law 260.10. But this only addresses persons less than 17 years of age. So EMTs at 17 are not an issue. Now, this may be an issue, note, for a certified first responder, for a CFR. Those people, all right, those individuals can participate at age 16. And although not a focus of this lecture today, I would strongly suggest that even though a person is allowed to be a 16-year-old responder, I would be very cautious about letting them go to certain ambulance calls. Think about hangings, suicides, traumas, if you can avoid it. Now, the Arts and Cultural Affairs Law says, it shall be unlawful for any person to employ, use, or exhibit any child under 16 years of age in any practice or exhibition or place that's dangerous or injurious to the life, limb, health, or morals of a child. So again, here we're talking to somebody who is less than 16 years of age. Interestingly, though, in the Arts and Cultural Affairs Law, it says that this paragraph does not apply to EMS service as a member of a certified volunteer ambulance service under the supervision of an EMT by youthful volunteers who are at least 15 years of age, who hold an American Red Cross card and first aid and emergency care card. So in other words, this doesn't affect 17-year-olds at all from being EMTs, and again, they can be. It also doesn't prohibit persons who are 16 years of age from being a certified first responder. And in fact, as we now know, even a 15-year-old is allowed to ride on an ambulance so long as they have a first aid and CPR card. So now let's get into the issues now that you understand the total backdrop of laws that talk about or govern age. Well, one question that comes up that we're often asked is, can a 17-year-old accept a patient refusal? For example, a 17-year-old, as we're going to talk about, doesn't have the mental capacity by law to form a contract. How can they accept a refusal? Well, as we know under the basic response protocols in New York State, a refusal is accepted only from somebody who has the capacity and competency to give consent to refuse. Well, capacity means that they're 18 years of age. Who's 18 years of age? The patient's 18 years of age. And the patient must be competent to refuse care. In other words, they're alert and oriented, and they can appreciate the risks of refusing care. But again, that's the patient. So a competent adult has the right to refuse care, and it's not in any way dependent upon the person who's taking the refusal. In other words, it's not dependent upon the age of the healthcare practitioner. And although a minor may not refuse care, that doesn't mean that a minor may not accept a patient refusal. So can a minor determine the capacity of an individual? Sure, why not? 18 years of age or more. Can a minor determine the competency of a patient? Sure, alert, oriented, time, date, place. Do you know who the president is? Do you know where you are? Of course they can. And this is in the BLS protocols, and it's in the patient refusal protocols on what an EMT would ask a patient to determine their competency. So state law has now said a 17-year-old is competent to determine the capacity and competency of a minor. So of course they can accept a refusal. They can determine the capacity and competency of an adult. They could take a refusal from an adult. But one might say a minor can't consent to terms of a contract. And that's true. By law, a minor does not have the capacity to consent to a contract so that they can bind themselves to a contract. But here, they're not engaging in any contractual negotiations, and they're not agreeing to anything. When you take a patient refusal, you're not contracting. All you're doing is witnessing the signature. You might be advising them of the dangers of refusing care and not accepting transport and treatment, but you're not contracting. So yes, in short, a 17-year-old absolutely can accept a patient refusal just like any other EMT. What about FERPA? Now, FERPA is the Family Educational Rights and Privacy Act. It's a federal law, and it protects the privacy of student education records. So this is going to be an issue when a 17-year-old, perhaps, is in an EMT course. In other words, who has the right to the records, the educational records? Is it the parent? Is it the student? Now, the law, this federal law, applies to all schools that receive funds under an applicable program of the U.S. Department of Education. So if you take a EMT course at a community college, which is very common, this law is very likely going to govern the educational student records. So Part D says that the students rather than the parents' permission or consent is required in certain instances. So, whenever a student has obtained the age of 18 years or is attending an institution of post-secondary education, like a community college, then parents no longer need to consent to the release of educational records, and only the students can obtain their educational records. Let me say that again. Once a student has obtained the age of 18, only the student has the right to obtain the educational records. And even if a 17-year-old is attending an institution of post-secondary education, community college, only the student can obtain their educational records. So if you are offering a course, be very careful. The 17-year-old now at a post-secondary college has the exclusive right to the release of their records. Don't give them to the parents. That basically sums up this slide. And again, if the student's under 18 and not at a post-secondary education, for example, they're taking it just through the fire department or they're taking the EMT course at their high school, then the parents retain the rights. But otherwise, at a community college, these 17-year-olds have the exclusive right to their educational records. What about clearing a 17-year-old as an EMT? What if you say, you know, I run the ambulance corps, the fire department, and I'm just really not comfortable with a 17-year-old going out and responding to certain calls or responding to calls at all? That's fine. You actually can. Just because somebody has obtained their EMT card at age 17 does not mean that you are required to allow them to do any operational activity. You might state, listen, we only want somebody who's 21 in order to drive. We may say that somebody has to be 18 in order to tech the call alone or tech the call at all. In fact, you're allowed to restrict your membership generally to 18 years of age. Not that we're suggesting that. We've seen pretty good results where you bring in members younger to an organization and allow them to, let the bug bite them earlier in their career than forcing them to wait till 18. But that said, if you want to keep persons who are less than 18 from being a member or from performing in any operational capacity, you can do that. What about ride hours? I'm an EMT. I'm 17. I have the right to be treated like an 18. That's not actually true. 17-year-olds, look, they're still not adults. As of age 18, they become a legal adult, but at 17, they're not. Frankly, we don't think you should leave a 17-year-old or 16-year-old alone in the station without at least 2 adults supervising them. And honestly, yes, we recognize that 18-year-olds are legally adults, but truthfully, it should be a 21-year-old who in this case is supervising the 17-year-old. Right? 2 21 or over should have to be present when somebody less than 18 is at the station or the firehouse. It's just a better practice. Now, the law doesn't give any prohibited hours for minors as far as number of hours or hours they can be at the station or firehouse, but they should always be properly supervised, and you can create any limitation on hours you desire based on the age, because after all, you're trying to protect them as well as the agency. Are EMT students required to be paid for training? Well, a student is an individual who is enrolled in and regularly attends a course of instruction at a state-licensed educational institution of learning, resulting in a certificate, completing residence requirements for a degree. A student is exempt from minimum wage and being paid minimum wage or being paid anything if they're working at a not-for-profit organization, which is set up and operates strictly for charitable purposes. So, for example, if you have a student who is working at your ambulance service and you also pay people, but you're not paying the student, that's okay, because the student is not working if they're fulfilling curriculum requirements for the class, or if the student is receiving supervised experience outside the class at another establishment. So no, you don't have to pay students who are working at an agency which otherwise pays people. What about preceptors? You know, as a 20, 30, 40, 50, 60-year-old adult, you may not want to be alone with a 17-year-old in the back of an ambulance. In fact, we'd advise you're not. But how then does a 17-year-old get precepted? In other words, can you refuse to precept a minor? Well, once again, there's no law on this. An educational facility is going to be obliged to accommodate the student, but you're not an educational facility necessarily when you take in an EMT student to be precepted. To be clear, no person is legally obligated to serve as a preceptor for anybody. We doubt the law would punish an individual for refusing to serve as a preceptor in order to avoid being alone with a younger person, such as in the back of the ambulance. But we do suggest that you try to make accommodations for this person. One, we want them to get through class. We want them to have places to become certified. And if you're one of the ambulance services who take the 17-year-old in, we'd like you to be able to do that. So how do you do that? Well, if you can, having 2 people, the driver and the tech, who hopefully are at least 18, ideally over 21, they would be with the 17-year-old at all times. But let's be careful. Let's not allow the 17-year-old to wander around the ambulance bays or station wherever they want. Let's make sure they stay in a supervised place. Let's make sure it's a public place, and let's keep them safe from themselves and from other people. Does the educational institution need to notify a precepting agency that we're sending a 17-year-old? Well, once again, no law on this, but we think it's the best practice. If you're going to send a 17-year-old, a person who's not legally an adult, to an ambulance service, you really should let them know that we're sending someone less than 17. And I will tell you this, I think that if you're going to send as an educational institution, if you're going to send a 17-year-old to a place where probably only 18 and aboves are working or volunteering, you probably should be telling that agency, listen, you are going to have some enhanced security and safety measures for these people. If you run the educational service that's sending the 17-year-old out, I'm strongly suggesting that you make sure that the place they're going will provide some safety measures. And I strongly suggest that you provide a list of safety measures that the precepting entity will agree to implement for the benefit of the 17-year-old, such as not allowing them to wander wherever they want, not allowing them to be alone with another individual in the back of an ambulance or in private locations, or alone at all unless there's two adults. Ideally, that the two adults are at least 21 years of age or over. We strongly suggest that because the precepting agencies may not yet be ready and set up to accept the 17-year-olds, that you work with them in advance to accept that 17-year-old. And don't wait until a day before they got to start precepting. Arrange this in advance. Can an agency refuse to employ a 17-year-old? Well, let's look at the federal and state laws, because there are actually laws on this topic. Federal law has an age discrimination statute, and it involves treating an applicant or an employee less favorably because of his or her age. But the Age Discrimination in Employment Act, the ADEA, forbids age discrimination, but only as against people who are age 40 or over. It does not protect workers who are less than 40 years of age. So federal law would not protect the refusal to hire somebody who's a 17-year-old EMT. What about state law? Well, state law has the New York State Human Rights Law, and this covers employers with 4 or more employees. Let's assume for the moment that volunteers won't be included in the definition of an employee. The age discrimination laws of New York State protect persons who are 18 and over from age discrimination in employment, in apprentice programs, training programs, promotion and termination. But again, that's 18 and over. 17-year-olds are not protected. So finally, a note on membership and voting. If you accept an active member as a volunteer, and the active member is less than 17, we are suggesting that they not be allowed to vote at membership meetings. They are not allowed to serve on the board of directors. They are not allowed to serve as an officer of the corporation. Why? Because a 17-year-old cannot bind themselves to a contract as a matter of law. How can they be expected to bind a corporation or to vote for a corporation? Well, I hope you found this episode of Penal Law Presents to be helpful. And stay tuned and come back for more episodes on interesting topics.